All right, all right, all right, all right. So here we fucking go. It is time, ladies and gentlemen, gentlemen and ladies. I don't know why my shit is like this. I'm gonna refresh. Potentially. All right, motherfuckers. That'll work. That'll work. For everyone that's not here right now, cheers to that. I fucking don't blame you one bit. Anybody else that might be watching this in the future, you probably have better shit to do with your time. And now for a bit of a comical relief in the form of implied racism. Yeah, that's right. That is right. And as always, right in the middle of the fucking stream. Bam. Out of here with that shit. I don't know you. And I may not know you. Cheers and good evening. I am Michael Talbert, the one and only Kevin Michael Talbert, also known as Bleak Narrative. The humbly, I might add, the best motherfucking guidance out of this hellhole that you're gonna find. Coming to you currently at the cost of nothing because I do this shit to do it. I feel that the people that fucking have to charge for their documents and courses do so because they haven't had any success with their process. I, on the other hand, have been swimming in it. The shit has worked really well for me. Fucking maybe not as much as I would like, but I don't intend on making anybody that ever has to come to me for help compensate for the fact that I'm not where I want to be currently. It's no one's fault but your own. You know what I'm saying? You got two hands, two fucking feet and legs that work, man. You see something over there you want, nobody else is holding that shit, get it. Does it belong to you and somebody else is holding that shit, go get it, go take it. You know what I mean? Life is literally a fucking tug of war. We go back and forth with this shit. When you give up and I don't, that means I get the ball. Simple as. So any fight that you're ever in, any battle, any adversarial fucking force or conflict or obstacle in your way that you're ever going to pass or come in your travels here is 100% you. It's all a mental game that you're playing with yourself. Everything has a series of responses. Nothing is that unpredictable that you can't fucking beat it. You know what I'm saying? So with that in mind, and with nobody watching because alt channels, now the main channel as the main channel was fucking destroyed and taken down from YouTube last week. Fucking awesome. And here we are. Here we are doing what? not so fast, motherfucker. Not so fast. Yeah, that is what's up. That is indeed what's up. Man, fuck. I am not used to doing these for a completely empty house. So you'll have to forgive me if shit starts to lag a little bit. To recap from yesterday, I had covered some shit on warrants in the stream last night. It went all right. It didn't go as well as I would have liked it to. I've got some plans on improving my format, but don't expect it to happen anytime soon. One sec. Oh, goddamn. Beautiful, sunny southeastern Kansas, where it is always raining until it's not. Not a fucking huge fan of this place, but it's where I'm at, and so we've got to do what we've got to do. You know, I can't leave it like this. If I'm here and I can fix it, I got to fix it. You know what I mean? Looking for something to occupy the time here while I'm waiting on some people to join us. Hold fast.
But soon, at least some corporations and governments will be able to systematically hack all the people. We humans should get used to the idea that we are no longer mysterious souls. We are now hackable animals.
Check this out. Ever heard the expression, there's nothing new under the sun? There were robots in existence in 1883. Look at these pictures. 1887. This man is getting his carriage pulled by a droid. See that? This is the famous Moorish boxer, Jack Johnson. Who was he fighting against? A droid. A bot. Here, the robot is on the stage being shown off to the crowd. 1883, they're showing the insides of the bot, the droid. 1893, here's a droid in the military. Frank Reed Jr. and his new steam man. Look at that. Marvel of the Klondike. Metal Man triumphs over an enormous grizzly. How about this one? Frank Reed Jr. and his new steam horse. Look at that. How about this one? Where do you think Star Wars got the ideas about droids from? They were already here. Wow.
Wow. Indeed. Wow, indeed. Yeah, history is a lie. Everything that you know of the legal system and our government is as well. That's why we are here tonight and at all, really. Post family, I don't have a whole lot else to exist for, man. So this is what we're doing with our time now. Fucking, I've come to terms with it. It doesn't seem to be that it's going to bother many people here because there are never many people here. That said, I'm going to go ahead and fucking get into it, man. Go ahead and get right into it. We'll pick up where we left off last night with warrants and false arrest and imprisonment, or being summoned to appear before a court that has no jurisdiction for a victimless fucking crime. So that's what we were fucking with. Might as well keep fucking with it until my buddy Steven comes or does not come. And if that's not within the next 20-30 minutes, I am the fuck out of here. There's nobody here to answer any questions for. So fucking, redundant shit. Redundant shit is redundant as fuck. So see what I got for you tonight. On my recents, I've got void judgments, bills of attainder, and what you should know about them by Palmquist. Objections to mere statements admitted as fact. Westlaw, full text item for false imprisonment. Reasonable suspicion, roadside case law. We're going to go ahead and go with false motherfucking imprisonment and dabs. False imprisonment and some motherfucking dabs. Because when in Rome, do what the drug addicts do. I think. Pretty sure. We're going with it. Survey says. All right. So this is Westlaw based on the Virginia annotated codes. As always, it's going to be different from state to state. So I would encourage you to look your own state's rules of evidence, rules of criminal and civil procedure up, or anything that's relevant to your problem. Don't ever take what I say for gold. You know what I mean? Take your time, do your due diligence, and take the head start that you've been given by somebody giving you advice and verify. Just check, look into the shit. You'll never, ever wish that you hadn't, and you will always wish that you had if you decide to move in an adverse fashion. That said, and summarily, I am not a lawyer. This does not constitute legal or financial advice. If you are looking for legal advice, seek the help of a competent, licensed attorney. And if it is financial advice that you're seeking, then consider speaking with a financial advisor. So, obstructing justice, resisting arrest, fleeing from a law enforcement officer, and the penalties of, effective July 1st, 2018. If any person without just cause knowingly obstructs a judge, magistrate, justice, juror, attorneys, or for the Commonwealth, witnesses, any law enforcement officer, any animal control officer employed pursuant to 3-2-6555 in the performance of his duties as such, or fails to or refuses without just cause to cease such obstruction when requested to do so by the people previously mentioned there, is guilty of a Class 1 misdemeanor. This is just a start. As always, they can toss any fucking list of things on top of some shit and really make your life hell if they choose to do so, and they will. So, if you're obstructing, make sure that you're doing it for a good reason. Just like if you're taking shit, make sure you know why, and make sure you know when it fucking stops. Make sure that you fucking know when it stops. Except as provided in subsection C to this code, any person who by threat of force knowingly attempts to intimidate or impede a judge, magistrate, justice, juror, attorney for the Commonwealth, witness, law enforcement officer, or animal control officer lawfully engaged in his or her duties as such, or to obstruct or impede the administration of justice in any court is guilty of a Class 1 misdemeanor. Any person who threatens bodily harm or force to these people is guilty of a Class 5 felony. Any person who willfully makes any material false statement or representation to a law enforcement officer, animal control officer, or anybody working in the course of conducting an investigation of a crime by another is guilty of a Class 1 misdemeanor. Any person who intentionally prevents or attempts to prevent law enforcement from officially arresting him without a warrant or with a warrant is guilty of a Class 1 misdemeanor for the purpose of this subsection. Intentionally preventing or attempting to prevent lawful arrest means fleeing from a law enforcement officer who has officer when the officer is in the officer applies physical force to the person. The officer communicates to the person that they're under arrest, and the officer has the legal authority and the immediate physical ability to place the person under arrest and does so. And B, the reasonable person who receives such communication or should know that he is not free to leave. Notes on decisions. Obstructing or interfering with the performance of duties of a ministerial officer, the nature, elements, and yada yada, so on and so forth of the offenses. Defendant did not violate statute, making it unlawful for citizens to refuse to stop their vehicles when commanded to do so by police. When he allegedly evaded a traffic checkpoint by turning into a gas station parking lot and exiting onto the highway on which he had just been traveling. Even if the checkpoint constituted a police signal or command to stop, the actions of the defendant took place 500 feet and one intersection away from the traffic checkpoint, and such a command did not extend over such a distance. This would be according to code, and they have the case law Bass v. Com, and that's abbreviated, so I'm really not sure what Com is. It would be the Commonwealth, I would assume. It's 525 South, or SE 2D 921, 259 VA 470, obstructing justice. That'd be under the code 121. Arrest because an officer has probable cause or had probable cause to arrest both brother and sister of fatally wounded suspect for committing minor offenses in officer's presence. Detention of brother and sister at the scene of shooting was consistent with officer's duties and did not constitute false imprisonment under Virginia law. This would be Fig versus Schroeder 2002. Even if the county sheriff had probable cause to believe that a school band director had violated misdemeanor obstruction of justice state by refusing to make band walk faster during a parade, misdemeanor violation did not authorize custodial arrest. Wow. Such that a sheriff did not have the authority to detain suspect for the purposes of suspect's false imprisonment claim under Virginia law arising out of the sheriff's actions for handcuffing him and leaving him on the curb for 15 to 20 minutes. That's Spires versus Sidenor 2021. That's SPIERS v. Sidenor, SYDNOR 2021. Sheriff and deputy had probable cause to believe that a truck owner who had refused to provide information to them or an alleged victim of a minor traffic incident involving the truck was obstructing justice, and thus the deputies did not violate the owner's Fourth Amendment right when they arrested her without a warrant. Yeah, well, that and this goes back to what we were talking about last night with the case in Kansas, Ellis v. State. Now, a gal had been doing some dope in a bathroom at a rest stop, Casey's or something of the sort. And the employees called her in because they were suspicious. The cop knocked on the door. She's like, yeah, I'm in here. I'm having some stomach problems. Ate something. Do I need to come out? He said, yes. Fucking one thing led to another. The officer noticed her hand shaking and mentioned it, and she said that while she would never do drugs in a fucking public restroom, he had a bag of meth in her purse and a pipe. And so they arrested her based on another warrant and charged her with the drugs as well. This was concerning a welfare check turning into a warrant check, turning into an arrest and conviction, which doesn't fly in my fucking state. But the important thing to remember here is that both of the officers, Officer Law and Officer Jacobs, were not employed with the sheriff's department. And so they were not deputized sheriffs. They were fucking municipal policy enforcers. Officer Schmedley, Officer fucking McDonald's, he doesn't have any goddamn authority over you. If my former roommate, the manager of the McDonald's, sees you coming out of his restroom and not having washed your hands, and he tells you to get back in there and wash your hands or you're going to get your pay docked, would you or would you not tell him to fuck off? That is the exact amount of fucking authority a cop has over you. A police officer is a policy enforcer and has no actual job other than to enforce municipal fucking code and to take your ass directly to a fucking magistrate if there's any kind of conflict. You cannot be taken to jail by a policeman. Any policeman that says that they have probable cause to take you to jail is retarded, and he is vulnerable to collateral attack for false arrest and imprisonment and magistrate failure. They have to take you directly to a magistrate without undue delay to answer for your crime. Doesn't matter if they witnessed it. Doesn't matter if it's based off of firsthand knowledge testimony given in the form of some fucking snitch or some witness. You must be taken before a magistrate by a cop. The chief of fucking police cannot arrest you and take you to jail. Not with a warrant, not without. And it's been this way since the days of the Pony Express and the fake fucking Revolutionary War, and it will always be this way because there are rules. There are rules in place for these fucking pieces of shit to enforce our right to not be fucking imprisoned by them. If a fucking cop could take you and put you in a fucking cell, put torture cuffs on you and hold you in the back of a car and then take you and put you in a fucking cell where your bond will be set by his buddies, then you don't live in a free country. And trust me, man, if you don't know this kind of shit, you don't live in a free country. You are a fucking slave on the plantation. It is not until you learn how to fucking protect yourself and enforce your fucking rights and I mean enforce your motherfucking rights that you are free in this place, and not a moment fucking sooner. If you don't know how to protect yourself from fucking federal and municipal fucking terrorists and tyranny, then, well, I mean, you're in the right place. And I'm not throwing stones, man. We all start somewhere. You know what I mean? I'm far from fucking knowledgeable on this subject. And maybe that's a little bit of imposter syndrome speaking, but I mean, I learn something every day. I really do. Every time I host a conference call, anything like that, it's generally always the same. Generally always. So, no officer could have concluded that a motorist's brief delay in responding to the officer's instruction to roll down their window during a traffic stop for speeding could have constructed or constituted obstruction of justice, and thus a police officer was not entitled to qualified immunity from a motorist's 1983 false arrest claim. Motorist was pulled from their vehicle and forced onto the pavement mere seconds after failing to respond to the instruction. She did not threaten the officer and did not act with any intention to instruct the officer. And she did not didn't employ direct action to resist arrest. Yeah, so it's like the Kansas case. First off, you got to keep your mouth shut. You can't talk to these motherfuckers. Second off, these people didn't take her directly before a fucking magistrate. And third off, there has to be intent. These people have qualified immunity. That means that they have to qualify for the fucking immunity. There are so many odious and obvious motherfucking things that they do that would fucking bar them from having this immunity. And if they act outside of what is called the scope of their employment, then they will be stripped of their fucking surety, and they will not be indemnified in any way, shape, or form, and can be sued professionally and privately, publicly in their fucking title, and as a man or a woman whose socks you will be wearing by the end of this motherfucker. Stick with me. I'm telling you, this shit is it's no joke, and it's not something that requires anything other than a little set of balls or the ability to act. Now, I don't have either, and I'm able to do this. If you can act like you have balls, or you just have balls, you're there. You're already beating my ass. I should be watching you on your channel, your modest sized fucking channel. God, it fucking sucks. I fucking hate everything about the reporting system, the flagging system here. It is a joke. Questions of weight and sufficiency of evidence. Defendant's flight from officers following a traffic stop was not sufficient to support a conviction for obstructing justice. You'll have to forgive me. There's all kinds of little shit like popping up over the words from all the hyperlinks in this document. I don't know how to shut that off, like keep that from happening without stopping the live stream. So I guess it really doesn't matter. It does not look like my guests are coming, and so I will be shutting this thing down pretty fucking fast, because I'm not gonna sit out there and do this shit when requested to, and rewarded by motherfucking spending more of my time talking to myself somewhere where motherfuckers can hear me, see me. It's fucking mildly embarrassing. Defendants, questions of law and fact. Whether defendants swerving a stolen vehicle towards the United States Park Police cruiser constituted the use of the car as a deadly or dangerous weapon was for a jury action charging the defendant with a deadly or dangerous use of a weapon in resisting federal officers, despite contention that the car was moving at speeds far too slow to have been found to be deadly. During its swerves, evidence indicated officers were forced to veer off into oncoming lanes of traffic, potentially exposing themselves to deadly head-on collisions. This would be 18 USCA subsection 111 and 114 US v. Garcia 1989, 86 F2D 114. Writ for certiorari was denied in 109 S Connecticut 2439 490 US 1094 104 LED 2D 995 obstructing justice 173. Now, is it necessary that I read all this shit to you? Probably not, man, because I don't really think anybody's ever going to see this shit, and I don't think that anybody will ever act on this shit to protect their interests anyways, just based off of the way fucking my peers have become. But I'm doing it because it's right. Like, if you're looking this shit up, you're studying case law, and you're using this shit for your findings of fact, your conclusions of law, and your paperwork and stuff, then you're going to need to know how to do this shit. Otherwise, you are an artificial person. You are deceased and civilly obtuse, mortuse. You know what I mean? Obtuse. Yeah, you probably are obtuse as well. I mean, if you're not on board with this shit, it's because nothing's happened to you yet. After something happens, you'll realize, what else is there to talk about? What else is there to fucking talk about? You want to talk about the feetball game? Man, I'm the #1 Superfoot fan, dude. We could talk about that shit. But let's talk about, the fact that there's a big boot on everyone's neck first. Subsection 19.2-81, arrest without a warrant authorized in certain cases. This would be effective January 15th, 2018 in Virginia, but as codified by federal law into your own the specific state's statutory code. It will read as follows, to some effect, with the potential for the order of everything to be mixed up, resulting in little more than the citation being or containing different numbers for you if and when used. So, the following officers shall have the power to arrest as provided in this section. 1, members of the state police force of the Commonwealth. 2, sheriffs of the various counties and cities and their deputies. 3, members of any county police force or any duly constituted police force of any city or town of the Commonwealth. And 4, the commissioner, members and employees of the Marine Resources Commission granted the powers of arrest pursuant to subsection 28.2-900. Regular 5 conservation police officers appointed pursuant to their state's code. 6, United States Coast Guard, United States Coast Guard Reserve Commission of warrant and petty officers authorized under their state's code is subsection 29.1-205 to make the arrest. 7, conservation officers appointed pursuant to their state's code. 8, full-time sworn members of the Enforcement Division of the Department of Motor Vehicles appointed pursuant to their state's code. 9, special agents of the Virginia Alcoholic Beverage Control Authority. 10, campus police officers appointed under their articles, Article 3, Chapter 8, Title 23.1, and members of the Division of Capitol Police. B, such officers may arrest without warrant any person who commits any crime in the presence of said officer and any person whom they have reasonable grounds or probable cause to suspect of having committed a felony not in their presence. Such officers may arrest without a warrant any person whom the officer has probable cause to suspect of operating a watercraft or motorboat while intoxicated in violation of their state's code or substantially similar ordinances of any county, city, or town in the Commonwealth, or II in violation of any order pursuant to 29.1 and may thereafter transfer custody of the person arrested to an officer. To any other officer who may obtain a warrant based upon statements made to him by an arresting officer. That's kind of crafty and a little fucked off. C, any such officer may, at the scene of any accident involving a motor vehicle or watercraft as defined above, or any motorboat, or any hospital or medical facility to which any person involved in such accident has been transported, or in the apprehension of any person charged with the theft of any motor vehicle on any of the highways or waters of the Commonwealth upon reasonable grounds to believe, based upon personal investigation, including information obtained from eyewitnesses, that a crime had been committed by the person and their presence, apprehended such person without a warrant of arrest. For the purposes of this section, the scene of the accident shall include a reasonable location where the vehicle of the person involved in an accident has been moved at the direction of any law enforcement officer to facilitate clearing of the highways or to ensure the safety of the motoring public. Such officers, within 3 hours of the alleged offense, arrest without warrant at any location any person whom the officer has probable cause to suspect of driving or operating a motor vehicle or watercraft while intoxicated in violation of blah, 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 or a substantially similar ordinance of any county or city or town in the Commonwealth, whether the offense or not was committed in the officer's presence. Such officer may, within 3 hours of the alleged offense, arrest without a warrant at any location any person to whom the office has probable cause to suspect of all of these things I mentioned above. And see, it might sound redundant and very verbose and beefy for them to write these things like this, but it's important. Legalese is not the same as English. It's literally a different trademarked and copywritten language that they use to fucking deceive us and do all kinds of stuff. So without a warrant or capias, persons duly charged with a crime may be arrested in another jurisdiction upon receipt of a photocopy of the warrant or capias, telegram, computer printout, facsimile printout, radio, telephone, or teletype message in which a photocopy of a warrant, telegram, computer printout, facsimile printout, radio, telephone, or teletype message shall be given. The name or a reasonably accurate description of such person wanted for the crime alleged. If I'm being stopped and there's lights on the vehicle that's pulling me over. That's the first thing I'm going to ask. Is there a fucking APV? You know, an all points AP like put out all points bulletin for a car matching this description. Has some child been kidnapped? Is there an Amber Alert polyclass? Like what's going on here? Is there emergency? How do you need my assistance? Officer Schmedley, Officer McDonald's. So, such officers may arrest without warrant or capias for an alleged misdemeanor not committed in the presence of the officer when they receive a radio from the department or other law enforcement agency within the Commonwealth that a warrant or a capias for such offenses on file. Such officers may also arrest with or without a warrant for an alleged misdemeanor not committed in their presence involving, oh my God, shoplifting or similar ordinances, carrying a weapon on school property or similar ordinances, assault and battery, brandishing firearm in violation of the state's codes, or destruction of property in violation of the state's codes when such property is located on the premises used for business or the commercial purposes of a similar local ordinance, or they have observed any of the alleged offenses. When any such arrest is based on probable cause upon a reliable complaint, the arresting officer may issue a summons to any person arrested under this section for a misdemeanor violation involving shoplifting or any of the above. So seizures of the persons, officers who had to run the tags on a defendant's automobile and learned that they belonged to a truck and did not have reasonable belief that the automobile was stolen, and thus unreasonably put handcuffs on a defendant while investigating a traffic violation, namely violation of a statute governing display of license plates that would warrant only the issuance of a summons for the violation, and thus the officer's decision to handcuff the defendant constituted unreasonable restraint. It's a false arrest. After the officer ran the tag, he received no report other than either that the automobile had been stolen, or no report that either the automobile had been stolen or the truck whose license plates were on the automobile had been stolen. And the officer did not testify that he observed any damage suggesting forced entry or the rigging of the ignition. That's Lawrence v. Com. It's Commonwealth 2003, 578 Southeast 2D 5440 VA Appellate Courts 95 Automobiles 349 15. Presence of or pursuit by officer. Officer had authority to arrest defendant without warrant for misdemeanors of traffic infractions committed in his presence. This is Nice versus Com, Neiss, Commonwealth. Possession, disposal of concealment of article, probable cause. Officer's subsequent observation the defendant had picked up his pace and entered a restaurant. As they approached him, that defendant had in his hand a small brown bank envelope, which was commonly used for drug trafficking in the area. Get the fuck out of here. And that the defendant appeared to be trying to get rid of it, coupled with the prior tip of advising officers that a male wearing a navy peacoat was on a certain street and had on his person a supply of narcotics was sufficient to establish probable cause. And yeah, it will be. This will be Oglesby versus the Commonwealth 1972. Any kind of reasonable articulatable suspicion that they can articulate, or any single articulatable fact that they can articulate, gives them probable cause. You can give them probable cause as well, just by the way you react to them, which is why you need to get over the fear of these fucking people. They have no authority over you, and everything that they're doing to you is fucking highly illegal and treasonous. It's seditious and it's treasonous. It's domestic fucking violence. These people are here to protect us and our property, and that is fucking it. They go back into the brother and sister of the fatally wounded person, Commonwealth Transportation District, or locally liable for damages in certain cases. Blah blah blah. Let's get that shit. No, I'm not. Any claim that was based upon any act or omission which had occurred prior to 1982. Any claim that against a transportation district based upon any act or omission prior to 1986. Any claim based upon any acts or omissions of the General Assembly or District Commission of any transportation district or any member of the staff thereof acting in his official capacity to the legislative function of any agency subject to the provision of this article. Any claim based upon any act or omission of the court of the Commonwealth or any member thereof acting in their official capacity or to the jurisdictional functions of any agency subject to the provisions of this article. And see, so that's why the language is important, because they, this is where they dance around. The word person is used 100 and some odd times in the UCC in different definitions. The United States that I'm aware of is 15 different things that I've come across, so 14 different things that I've come across so far. And that's just the United States. That's not the United States of America. And all that these assholes have done is they've cleverly named a business like a corporation after the geographical setup of this fucking land that we live in. There are a bunch of states. We are united in our fucking lie that we tell each other about being free from England and being free from the king. And so they call it the United States, thinking that you will think that that's what it is, and you do. It's just like the citizen thing. People are afraid that they'll get denied medical care or government assistance or employment or residency in some kind of fucking school if they don't say that they are a U.S. citizen. But I mean, listen to how long these sentences are that I've been reading. These people do not fucking put words in there that they don't intend to, and they don't leave out words that should not be left out. They don't. I mean, this facilitates their very livelihood and existence. So, how are we doing? Cheers, cheers. So, any claim arising in connection with the assessment of or collection of taxes, any claim arising out of the institution or prosecution of any judicial or administrative proceeding, even without probable cause. Wow, no kidding. Administrative, yeah, I suppose that's why. Fucking commercial courts, man. It's Mickey Mouse commercial courts. Any claim by an inmate of any state correctional facility as defined in the state's code there is 53.1-1, unless the claimant verifies under oath by affidavit that he has exhausted his remedies under the adult institutional inmate grievances procedures promulgated by the Department of Corrections. The time for filing said notice of tort claim shall be told during the pendency of the grievance procedure, meaning that it runs concurrent with it, same time. Nothing contained herein shall operate to reduce the limit or extent to which the Commonwealth or any transportation district or any agency or employee was deemed liable for negligence. Nor shall any provision of this article, if applicable to any county, city, or town in the Commonwealth, or be so constructed as to remove any way or to diminish in any way the sovereignty of and the sovereignty immunity of any county, city, or town in the Commonwealth. This is where I'm going to put a fucking bow in it, dude. A pin in it, a little bow, peep bow, like a fucking big bow. I'm going to get a tramp stamp of one of those. It's going to be awesome. You motherfuckers will be jealous. Gotta love it. Gotta love it. Get it, Mikey.
Man, some days I just wake up and I miss the fuck out of mama. I don't know. I mean, really miss her. You know what I'm saying?
So you're normal. Mm-hmm. That's wrong.
We are all homosexuals.
Yeah. No.
You're suppressing your sexual desire.
You're right. I'm a gay guy. Why do you care?
I'm on the same page with you.
Oh, wow.
We're going to have sex.
Yes.
Good.
Seriously, though. Something about it. I don't know. Bro, wake the fuck up. They're a trap. Jesus Christ.